Chair lays out Senate Bill 29 and asks Senator Senator Hughes to explain the bill.
Thank you, Thank you, Mr. Chairman, and thank you, members. Senate Bill 29 has to do with Texas as the destination for business. More business in Texas means more jobs, means more growth. And so we want to continue to attract companies here, in this case for legal domestication, for their incorporation here. So the bill does a couple of things. It codifies the business judgment rule. That's already the law in Texas, but it is a common law made by judges, and those things can change. So by codifying the business judgment rule, we'll give directors and shareholders confidence that courts aren't going to second guess their business decisions unless there's fraud, of course, or intentional misconduct. Also, public companies and large private companies can set a 3% ownership floor for derivative suits. That means frivolous claims could be blocked and letting leaders focus on growth and not litigation. Again, this would be allowed for corporations forming in Texas if they meet certain criteria. Also, we're going to send to the newly created Texas business courts the ability to confirm director independence early in the process. What does that mean? Let's say a company needs to do an interested transaction. Senator Perry, this stuff means more to you as a CPA than it does to most of us. An interested transaction between there's a shareholder and an employee of the firm and so of the company. And so that's got to be handled differently. And so under this law, they can go to the court, the business courts, and the shareholders get approval of this independent committee, and they can then take action without fear of being second-guessed, again, unless they do something fraudulent or something along those lines, intentional misconduct. Also, Senate Bill 29 would let firms set venue and lock internal disputes in those business courts, consistent with what Texas has been doing to give predictability and consistency so that as businesses consider leaving Delaware or incorporating somewhere else, we want them to continue to think of Texas. Also, emails and texts. Of course, a shareholder is entitled to inspect books and records of a corporation. This clarifies it's not talking about emails and text messages unless those communications drive corporate actions. And again, this is about common sense approach to give companies certainty. We want them to come to Texas. And I do have a committee substitute.
Chairman Hughes, send up committee substitute for Senate Bill 29. I ask the author to explain the differences between the sub and the original file.
Thank you, Mr. Chairman. I'll just go briefly through these. We amend the substitute, amend Section 6 of the bill. We were just talking about books and records and whether emails and texts are included in that. Section 6 clarifies that an email or other electronic communication does qualify as books and records if it effectuates a corporate act. If by that email or text we are taking this action, then of course it's relevant and subject to that disclosure. Amend sections 8 and 13 to give further details on that process to have directors certified as independent when we have an independent committee to review a transaction. These are non-substantive changes, but they make it more clear. Also, amend section 10 to clarify that the relationship between the business judgment rule and exculpatory provisions available under the existing business organizations code are consistent. And again, it's a clarification of the language in the original bill. And then finally, we talked about putting a threshold in place for derivative suits. Now, we apply this to publicly traded companies, the thinking being that if the stock is traded, then folks always have a recourse. They can always sell their stock. In the originally filed bill, this was a drafting error on our part. The originally filed bill would apply to publicly traded companies and also to private companies, but this committee sub makes it clear we're talking about private companies with 500 shareholders or more. Of course, that's where SEC regulation is triggered at 500 shareholders, and those shareholders are going to be sophisticated investors, and so we do put them in a different category than like a family business or a corporation. Family business happens to be a corporation. That's what the committee substitute does, and we do have some very helpful witnesses who will elucidate these points and walk them through us, but of course I'll do my best to answer questions in the meantime. Senator Bardwell.
Thank you, Mr. Chairman. There are three places in the bill that, and maybe some others, but when I read through it, that used a term called derivative proceeding. What is a derivative proceeding?
Thank you, Senator. So derivative proceeding, sometimes these are called shareholder derivative suits. And again, the witnesses can help more on this, but if you're a stockholder in a company and you're concerned about how the company is being managed, about decisions that are being made, you as a stockholder, as an owner, can file a lawsuit, and it's called a shareholder derivative suit. It derives from your authority as a shareholder. This is not talking about
Derivatives as an investment
you bet. It's not talking about mortgage-backed securities or derivative instruments like that. That's a great point. This is about a lawsuit brought by a shareholder against the company. And I'll get the experts to help with that, but that's an important distinction, and thank you for asking about that.
Thank you.
Senator Hinojosa.
Thank you, Mr. Chairman. Just wanted some clarification as I'm trying to understand the language there. So this would offer those protections to directors in both publicly traded and private corporations?
Senator, yes, with this caveat. If this committee sees fit to pass the bill with the committee substitute, it would apply to private corporations only with 500 shareholders or more. Because when you get to 500 shareholders, you're subject to SEC regulation. So that is more like a public company. So for smaller companies, less than 500, if the committee substitute's adopted, it will not apply as far as the derivative suit limitation. That'll be for 500 shares or over.
Okay, thank you.
And thank you, Senators. These are, I know that members of this committee are well-versed in business and various subject matters. This is a very narrow in the sense of a area of the law we don't see very much. But if we think about the practical implications of this bill, we have the opportunity to really entice business to come to Texas. And again, that's more growth, that's more jobs, and that's the goal here. And again, the experts will be able to correct what I've said gently, I hope, and answer our questions. If there are no more questions at this time, then we'll open invited testimony. On Senate Bill 29, the chair calls Professor Shane Goodwin, Eric Lentell, Christopher Babcock. First, come on down, take any of those seats. And I'll just say to each of the witnesses, please don't just feel free, but accept my encouragement to correct or clean up anything I said. And you don't have to be nice. I know you will, but you don't have to. And just give us your testimony. We're going to have questions for you. This is really important. The subject matter can be a little bit dense. And so we want to make sure that the members of the committee and those who are watching and participating have a handle on what's being proposed here. So with that, welcome. Start over here. Introduce yourself and give us your testimony.
Well, actually, I think Mr. Babcock was going to lead off.
Very good. Counsel, get close to that microphone, introduce yourself, and go ahead.
Yes, sir. Good afternoon, and I'd like to start by thanking you and Lieutenant Governor for the leadership in introducing this legislation for the state of Texas. My name is Christopher Babcock, and I am the president of the Alliance for Corporate Excellence. I'm a practicing attorney in Dallas, and I focus on corporate law matters, including corporate governance in my practice. SB29 introduces reforms to the Texas Business Organizations Code that I believe will make Texas a significantly more attractive jurisdiction for companies to establish as their legal home. You'll hear from other members of the business community the effect they expect this bill will have on drawing companies to Texas. A basic premise of corporate governance is that decision makers need to operate under rules that are predictable, stable, and knowable, so that they can deploy capital without fear that their decisions will be second-guessed after the fact in hindsight. Historically, Delaware corporate law provided these features, and many companies elected to incorporate in Delaware for that reason. Recent decisions in that state have challenged the assumption as to whether Delaware remains the right home for corporate decision-making. SB 29 makes Texas the right home for corporate decision-making by introducing a series of amendments to Texas law. And I'd like to mention in my prepared testimony 2 key amendments. First, as the chairman mentioned, SB29 codifies the business judgment rule. The business judgment rule is the principle that a court should not substitute its own business judgment for that of a corporation's proper decision makers. And it's a cornerstone of corporate law. It serves to ensure that business decisions about deployment of capital, operations, and how to grow the enterprise are made by the corporation's shareholders and their duly elected directors, and not second-guessed by the courts. Codifying the business judgment rule and statutorily clarifying its scope gives guidance to allow boards to make decisions about how to run their businesses, confident that they can know and comply with the rule. Second, this bill empowers publicly traded corporations and large private corporations to establish an ownership threshold to be met before a shareholder or group of shareholders may bring a derivative claim. A derivative claim is one that belongs to the corporation itself, and the shareholder has the right to pursue that claim on the behalf of the corporation. And this provision, this threshold, helps ensure that these claims are brought for the benefit of the corporation's shareholders and not by mere nominal stakeholders without a true economic interest in the corporation. These and the other provisions of SB 29 will create the legal framework that corporate decision makers need to confidently operate their businesses. You'll hear from Mr. Goodwin and Mr. Lentel the effect that they anticipate these amendments will have on the business community and the opportunities the reforms proposed for the bill can create for our state. I'm happy to answer any questions, and I thank you for your time.
Thank you, and we'll hear from each witness, and we'll have questions for the whole panel. Thank you very much. Who's next?
Great.
Professor, go ahead.
Hi. Good
Dean.
afternoon. Good afternoon, Chairman Hughes and esteemed members of the committee. First of all, I would like to thank you for bringing this along with Lieutenant Governor Patrick for the leadership to make Texas the unrivaled leader in business, economic development, and jobs. My name is Shane Goodwin, and I come to you today in support of Senate Bill 29. I bring more than 30 years of experience as a practitioner, investor, board member on both public and private companies, and a professor in corporate finance, mergers and acquisitions, investment banking, and I've worked at many firms such as Goldman Sachs, Citigroup, and Wells Fargo Securities over the years. I've also advised over 250 M&A transactions totaling $50 billion and executed over 100 public and private equity investments exceeding $40 billion. Beyond my experience in the banking and capital markets, I currently serve as the Associate Dean and a finance professor at Southern Methodist University's Cox School of Business and an adjunct professor at SMU's Cox School of Law. Both my work in academia and industry focus on corporate governance, mergers and acquisitions, shareholder activism, and financial regulation, issues at the core of Senate Bill 29. Through my decades and experience of advising companies, serving on boards, and conducting research, I have firsthand knowledge that legal certainty, business-friendly policies, and clear regulatory frameworks impact economic growth, job creation, and investment decisions. And that is why I support Senate Bill 29, which modernizes Texas's corporate law and positions our state as the premier destination for business and corporations and economic expansion. So why is Senate Bill 29 critical for Texas? For decades, as Mr. Babcock had mentioned, Delaware has dominated corporate and corporations. Nearly 70% of Fortune 500 companies have chosen Delaware as their legal home. However, Delaware's legal system has become increasingly uncertain and unpredictable, and the legal risk for corporations, their boards, and shareholders intensifies. And this uncertainty at this moment is already having a negative effect and somewhat of a chilling effect for companies while they're making these decisions that are headquartered here in Texas. As Mr. Babcock mentioned, Senate Bill 29 offers some very compelling features. I'll just highlight a couple. Codifying the business judgment rule ensures that directors and officers of Texas corporations can make business decisions without constant threat of after-the-fact second-guessing by activist judges. By protecting responsible risk-taking, this bill promotes innovation and job creation while maintaining accountability to shareholders. Ensuring derivative litigation is led by shareholders with a genuine stake in the business. This empowers corporations to set reasonable ownership thresholds for shareholders filing those suits. It provides legal certainty. This bill allows Texas-based corporations to designate Texas courts as an exclusive forum for internal governance disputes. This ensures that Texas companies can operate within a predictable legal framework. Passage of Senate Bill 29 represents an important step in solidifying Texas as the economic engine of the nation. With this legislation, Texas will become not only a hub for corporate headquarters and operations, but also a premier legal home for businesses seeking the predictable, and innovative, friendly business environment. I often highlight how Texas has led the nation in corporate relocations over the past decade, with 100 major companies relocating to this great state, choosing not to move just their headquarters, but their operations, employees, and long-term investments to our state. That decision is not made lightly. It is a strategic, high-cost endeavor driven by Texas' pro-business climate, skilled talent, and our low tax structure. If companies see Texas as a great place to build, grow, and employ their workforce, then why wouldn't they also ensure that their internal corporate governance affairs are governed and adjudicated here? It only makes sense that the same state they trust for economic opportunity should also provide a clear, predictable, and business-friendly legal environment, one that protects their ability to operate effectively and remain competitive. As someone who has spent decades advising businesses and serving on boards and researching corporate governance, I can say with confidence that Senate Bill 29 is a game changer. It will provide businesses with certainty, promote economic growth, and ensure that Texas remains the best state to do business. I look forward to discussing how this bill will drive the business investment, enhance Texas's corporate legal framework, and strengthen our economy for decades to come. Thank you.
Thank you, Dean. Welcome. Introduce yourself. Give us your testimony.
Good morning, esteemed members of the committee. My name is Eric Lintel, and I am General Counsel for Archer Aviation, one of the global leaders in developing the technologies and aircraft to power the future of advanced aviation in both commercial and defense sectors. Thank you for allowing me to be here today to testify on behalf of Senate Bill 29. I have worked as an in-house corporate lawyer at innovative companies for going on nearly 20 years. Before Archer, I worked at Google, and prior to that, Fitbit. Today, I'm here to talk to you about Archer and how these reforms could attract companies like ours to change their state of incorporation to Texas, and along with it, expand business operations and bring significant economic activity. Archer was founded in 2018, is headquartered in San Jose, California, and publicly traded on the New York Stock Exchange. I joined the company almost 4 years ago when the company was under 100 employees. We now have over 1,000, with the vast majority being based in our offices in the US. In November 22, we unveiled our first planned production aircraft, an all-electric vertical takeoff and landing aircraft, more commonly known as a flying electric taxi. At the end of last year, we launched Archer Defense, entering into a strategic partnership with Anduril Industries to jointly develop a next-generation hybrid electric propulsion aircraft for defense applications. We have also now opened and begun production at our high-volume aircraft manufacturing facility, which is a 300,000 square foot facility located in Covington, Georgia, just outside Atlanta. Archer is first and foremost working to commercialize our air taxi operations in and around major cities around the world. To do so, we have forged strategic partnerships with some of the leading airline operators in the world, including Southwest and United Airlines. With them, we are currently exploring the potential to bring our air taxis to both Dallas, Fort Worth, and Houston. When Archer was originally founded, it was incorporated in Delaware due to the state's history of having such an established and predictable corporate law framework. However, the landscape in Delaware has become increasingly challenged. At Archer, we have faced many of the challenges SB 29 is looking to address. That is why SB 29 presents a compelling case for us to change our state of incorporation to Texas. We have been in active discussions on this issue with our board and are looking to make a decision soon, as our annual shareholder meeting is coming up. There is no doubt that SB 29 would position Texas as a rival to Delaware by blending legal clarity with operational advantages. At Archer, we believe there is significant value in having our legal state of incorporation in a state where we are looking to have significant business operations. That is why we are strongly considering moving our state of incorporation and investing in building out our business operations and infrastructure in Texas. For example, we are currently considering whether to build out battery cell and composite manufacturing capabilities here, as well as bringing our early air taxi operations, which together could result in thousands of good-paying jobs right here in Texas. Thank you for your leadership and for considering how these reforms can help fuel companies like ours to continue to ensure the U.S. leads the way when it comes to innovation.
And thank you for your testimony. I'm going to ask a few questions of the panel, and of course, we'll yield to the members of the committee. Thank you each for being here. We use the term internal affairs sometimes, so help us understand the type of litigation that we're dealing with. So our understanding is this is litigation between shareholders and management. This is not about litigation between our company and another company, or our company and another business or an individual. If someone alleges that our company breached a contract, that's not affected by this, if it's dealing with an outside company. So far, so good?
Yes, sir.
And if there's an allegation that our company has harmed someone, run over someone, polluted someone, whatever the allegation might be, if we're dealing with persons outside the corporation, that litigation is not affected by this bill at all. Is that right?
You are correct, sir.
Okay. Help us understand what we are dealing with here when we talk about internal affairs.
Yes, sir. An internal entity claim is a claim that concerns the internal affairs of a corporation. That's defined in the statute essentially to be matters relating to the governance of the corporation, decisions by officers, directors, and others, and matters concerning the ownership or rights of the equity interest, the stock of the corporation.
Let me also ask about publicly traded corporations and private corporations. Most of our focus in our discussions has been on publicly traded corporations. So the shares are for sale at some stock exchange, hopefully more and more of those in Texas, but on some stock exchange, those shares are available. But of course, we talked about how in the committee substitute, we're going to clarify that for private corporations, we're talking about 500 shareholders or more. Help us with that distinction and how 500 shareholders or more differentiates those private companies from a mom and pop or a business back home we might be familiar with. Walk us through that, please.
Yes, sir. The intent of giving corporations the ability to set a derivative threshold is to make sure that when someone takes a claim that belongs to the corporation for the benefit of the shareholders, that person really represents the shareholders with an economic stake in the company. That's a problem you commonly see in public companies where outside groups with very little shares bring a case that the majority of the shareholders don't support. That's not a problem with a closely held family corporation. That's not a problem with a small company. And our goal, we view as empowering shareholders, not trying to take away the rights in these contexts where every shareholder has a close and intimate relationship to the company in a way that may not exist in a publicly traded corporation.
Thank you very much. I may have some more, but I'll yield to the members of the committee. Senator Safferny, did you have questions?
Yes, I do.
I'm proud to recognize the Dean of the Senate.
Thank you, Mr. Chairman. And this is to any one of you. How can we maintain our business-friendly reputation, so well-deserved, and yet at the same time ask relevant and pertinent questions related to the energy and water needs of businesses that want to move into Texas?
I'm sorry, could you repeat that question? I apologize.
Well, I asked it off the top of my head, so it may not be exactly like.
I bet she can do it.
I said, we're so proud of being known for our business-friendly environment in Texas, but how can we maintain that reputation and ask relevant, pertinent, appropriate questions to businesses moving into Texas about their energy and water demands on the state of Texas?
I think that's a great question, and nothing in this bill prevents us from asking those questions. This bill concerns internal decision-making by directors and shareholders and officers. It does not address the power of the state to regulate a corporation. It does not address the questions that can be asked. And so I don't know if I have a good answer for you as to how the state can ask these questions, but I can tell you this bill does not limit the state's power in that respect.
And I know that it does not, but my question is, how can we do that? In other words, we don't want to hurt our reputation. We want to be known as business-friendly, but we also want to ask those pertinent questions. And if you were before the Business and Commerce Committee, those questions would be asked.
No, I appreciate the question. I very much appreciate those. Those are...
I'll get you.
Those are questions that are beyond my expertise, and I don't want to pretend to be an expert on water use and energy questions. I think they're very good questions, and I think that our state has the power to ask these and appropriately manage our resources so that we can grow our economy while preserving what we have. But any particular policy there would be beyond my area of expertise.
Yes.
And Dean, I think, Professor, go ahead, then I think Senator Perry wants to respond to the question as well. Senator Perry, you go ahead, then we'll come
I was
back
just
to you,
going to
Dean.
say, as water has kind of been on in my picture the last few years, what we're finding is companies are beginning to ask questions about natural resources and power if they're having the conversation. And truthfully, it works well when both sides are very transparent and have those open dialogues so that there's not a unrealistic expectation that can't be met. Or usually what it is, we can do this, but it's going to take a little bit of time. And what I'm seeing and what's been encouraging is the companies looking to Texas understand where they're moving to, understand what's available. They know what they need. Texas knows what it can provide. And then they work out that balance on how to meet those needs responsibly. So it's happening, and it's surely just, it's kind of a part of the process. If they're looking at spending billions of dollars of infrastructure, they're having those questions on the front end now and asking those questions. And it's not a negative that Texas says, we're here today and we're moving forward tomorrow. And after we leave this session, I think those answers will be even more clear. But there is an open dialogue. And I'll give you a good example, though. It's existing businesses seeing where our water supplies specifically are. There are existing businesses in the Corpus area that for numerous years have actually contributed on a front end to a fund to actually build out water supply. So we've got great corporate partners and we'll continue to have them. I think the key here is communication. So it's not a state doesn't get to tell them what we have and that they don't get to ask questions. It's a very open dialogue with that kind of money involved. But I've seen it firsthand in Corpus area. Those corporate partnerships of people down there needing more have stepped up, if you will, and the rates reflect a little bit of a buy-in to front load some of the cost of jump starting those infrastructures. So we're in a good spot, a great spot this session. We'll leave here hopefully with a plan that can address concerns coming in because they don't need everything today. They just need to know the state's going to work on it to have it solved for tomorrow. That's just been my experience in the water world.
Thank you. Did you have anything to add?
I did, Senator. What I do know is this bill doesn't preclude anything to obviously afford that, but what I can offer you is I currently serve on a board of a clean tech company that's actually focused on water reclamation from produced water out in Midland. And that was actually a veteran-started business from our Tier 1 operators who actually just thought of the idea and it generated out in California, but they actually decided to move here in Dallas. But in Texas to actually produce this idea and actually been very successful doing it. So I don't think there's anything that would preclude it. If anything, it would actually encourage it because of there's actually such great corporate governance around here to support their initiatives.
Thank you. I support this bill and intend to vote for it here and on the floor, in the Senate rather. But my very important question, because of feedback I have received, is what do you say to critics of this bill who say that it places business interests before the interests of workers, consumers, and communities?
What we would say is that this bill clarifies internal corporate decisions. It does not affect the rights of workers, of communities. It does not prevent corporations from, it does not take away anyone's rights. So we talk a lot about how internal entity claims are governed. Those aren't claims between a company and its workers. Those aren't claims between the company and its communities. And the rights of those other constituents are preserved and not hindered at all by this bill.
Well, then that's what I'll tell them. Thank you so much. Thank you, Mr. Chairman.
Thank you, Dean. Let me ask the panel a couple more things because I may have glossed over some important matters when I presented the bill. We talked about the business judgment rule. And I mentioned this is already the law in Texas. It's common law or judge-made law. And so this bill would codify it, place it in statute where all courts would be bound by it. And we talked about how it gives business some certainty, but talk a little bit more about what that means because we don't want to give business a blank check. Help us understand the business judgment rule and why it should be codified.
Absolutely. So the business judgment rule begins with a premise that corporate decision makers are experts at corporate decision making, and courts are experts in matters of justice. To the extent something is a business decision, it should be left to the business decision makers, the board, I'll just say as a shorthand. It should be left to the board so long as rights and just actions are followed. And so the codified business judgment rule we propose makes it very clear. A claim for misconduct or fraud or malevolence, some affirmative bad act by a corporate director, is still subject to judicial remedy. We're not trying to take, we don't try to take that away. What we do try to say is that you can take 100 years of Texas common law, you can put it in one statute where it's easy to find and review, and you can be protected against future changes in law. Sorry, sir, you look like you had a... What we have seen happen in other states, for example, is you start with this same core, and it gets whittled away and it gets changed by sometimes cases where the initial case decision is a good one, but over time it expands to something that leads to significant second guessing of decisions. And what I mean by second guessing of decisions is not, well, were you looking out for yourself rather than the shareholders? That would be fraud, that would be intentional misconduct. What we're looking at is when a company's in court, it probably means something bad happened. And if something bad happened, it may have been something that a board could not have predicted, that a board looked at, made a risk allocation, and tried to decide. It is inappropriate to judge that decision in hindsight once risks have played out. And so by codifying, you create certainty, you ensure that future laws, future decisions don't whittle away uncertainty, and you preserve a judicial remedy where there are bad acts by corporate decision makers.
And so along those lines, that's very helpful. So would it be fair to say that we want to encourage the leadership of companies to innovate, to take risks, to increase the shareholder wealth, to benefit society? We want to encourage that. We don't want them to worry about getting second guessed because a decision they made ended up not being a wise decision. If they made a good decision based on the information they had, they should have a safe harbor. Is that too much to say? Is that a fair way to describe it?
That is a great way to describe it, sir. That is correct.
Thank you. Let me ask you all, Senator Birdwell, go ahead. Oh, thank you. Let me ask one more, then I'll yield back to the committee. Thank you, each of the members and the witnesses, for your indulgence. Let's talk about these independent committees. I gave a very cursory explanation. You gave a better explanation, but tell us a situation where an independent committee might need to be set up, why that would happen, and then what this bill would do. I think it's sort of in the same vein as the business judgment rule. Help us understand that. And again, it's a great point that Senator Zaffarini made. We are not talking about claims that workers make against a company or claims that the neighbors or the community makes. This is only about the relationship between the shareholders and the management. Is that right?
Yes, sir.
So tell us about these independent committees. What are they? Why do we need them? What would this bill do?
Yes, sir. So let's say, for example, that you have a company that is operating in any particular space, and there is a value accretive transaction. The company believes it can.
A value accretive transaction.
Sorry.
Everybody got that but me, but go ahead. Tell us what that means.
There is a transaction being explored that the company thinks will benefit the corporation and will benefit its shareholders. However, that transaction may be with, say, another director. A director may own a different company that the first company wants to acquire. Now, we don't want someone deciding something with, their hands in both, and we don't want someone deciding something who's on both sides of the issue. So a company might say, we think this transaction looks like it will be really good for us and for our shareholders, but we want to make sure that's not being tainted by a director who's got an interest in that transaction. And so we're going to form a special committee, an independent committee of directors who are independent, who we believe have only the best interests of the company in mind and who are disinterested from the transaction. Because our view is that it's best to let these disinterested persons look and evaluate and make sure they agree the transaction's the right one to do. That's why you might form an independent committee.
And so Let me change, that's very helpful. Let's talk about the law today. Before, we don't know if this bill may not pass. I don't want to be arrogant and assume it will. It should, but let's say the law today, before this bill passes, how do you go about appointing that independent committee? What's the process?
Yes, sir. Before the law passes, the board would gather, they would identify the known conflict. The board would select directors who the board believed were independent. They'd do their diligence. They might ask some questions. They'd discuss what they know. The board would then appoint the independent committee and empower them to review and determine the transaction under the current law.
Go ahead.
Now, under the current law, what happens is the board has believed that these directors are independent. Nothing happens, nothing is publicly disclosed, nothing comes out. The transaction proceeds, and someone has a challenge with the transaction. Maybe it's someone in good faith, maybe it's someone in bad faith, but someone says, hey, I'm not happy that the corporation entered into this transaction, and they bring a lawsuit. At that time, because under our common law, courts respect the business decisions of the boards, the plaintiff would generally say, I believe that the members of this committee are not independent. And so the corporation has done significant work in exploring the transaction, in exploring the benefits to whether it's going to be successful or not. And all of this is done before the corporation has certainty that a court's going to believe that the directors that appointed as independent are independent. What that means is corporations often don't do transactions that they think would be good for the company because they're afraid they're not going to be able to prove that directors are sufficiently independent to be comfortable that that transaction will be upheld.
That's the current law today.
Yes, sir.
If Senate Bill 29 passes, what would change in how we appoint that, how we set up that committee, and how that affects the transaction?
What would change is the committee is still established, the board still does its diligence. The corporation then has the option to petition the business court, or if they're not in business court jurisdiction, another court, but they petition, presumably the business court, to say, we'd like to form this committee to evaluate transactions with with these persons. We want to give you all the facts that we can to the court. We'd like to appoint a neutral attorney and to let the corporation shareholders suggest alternative neutral attorneys to serve as a voice for the shareholders, not in that, for the non-directors, the independent shareholders. We're going to go to court and we're going to test to find out whether these directors really are as independent and disinterested as we say they are. And the corporation's going to be encouraged to give as much information as they can, because the result of this hearing is not a preclusive determination that can never be challenged. Rather, it's an establishment that, based on the facts the corporation said, these directors are independent. And so if the corporation was honest and upfront, it can be comfortable knowing that its independent directors will survive judicial scrutiny.
Chairman Hughes, if I can just add a note more as a board member.
Go ahead, Dean.
And somebody that has actually advised companies, primarily Delaware-related companies, I think this part of the bill is a game changer. I think it's extremely innovative. So it doesn't either chill doing a transaction or getting second-guessed by others after a transaction. So I do think this is an extremely innovative feature.
I'd like to add something as well. I think it's hugely valuable. For example, I'm dealing with one of these derivative claims right now in Delaware for a transaction that happened in 2021. We've spent tens of millions of dollars on litigation as a result of it. What we did is we created an independent committee. We were advised by an outside law firm that committee was independent. And so this would give us a step further to say, okay, we're not going to stop at that outside law firm. I'm going to go to the courts and have the court say whether or not they agree with that outside law firm's advice, and allow us to go into that transaction, enter into the transaction with that certainty, and not have to spend the next several years afterwards in litigation and millions of dollars of costs and sufficient amount of time.
Thank you for that. Senator Betancourt, you're recognized.
Thank you, Mr. Chairman. I think you mentioned that acoustics in the room are horrible. You said that no independent board member would survive a certain condition. You mentioned it just briefly.
Sorry, what I said is that the presumption is that the directors are independent based on the facts. But if there were facts that weren't disclosed, right, this doesn't allow a corporation to say, here's the rosiest story about these directors and then preclude a challenge. Instead, what the corporation says is, here are the facts we know. We believe these are all the relevant ones. And if those are all the relevant ones, then they've got a presumption that the directors are independent before they've gone down years and millions or billions of dollars in effecting a transaction.
Yeah, right.
Yeah.
Okay, thank you.
Thank you, Senator Betancourt. Senator Hinojosa, do you have questions? You're recognized.
Thank you, Mr. Chairman. And I apologize. I'm just trying to fully understand, and I think I have it right. I just want to just make sure. So your derivative claim threshold, you're saying that's for publicly traded companies and private entities with 500 directors or more, or greater, right? And that's to create that threshold. I think I understand that part of it. Is that
Yes,
Shareholders, not
shareholders? Excuse me, shareholders. Okay, that makes a little bit more sense.
That would be a big board.
Now, as far as codifying your business judgment rule, does that also have a threshold, or does that apply just for corporate law, even for small business? I know that's more rare for have these kinds of incidences for small business, but
So the business judgment rule applies to any corporation that's listed on exchange or corporations that opt in. That is, any small business that's comfortable with the current rules, that feels, hey, I know how Texas law works, may keep the current Texas common law. But any private corporation that says, I think these are likely to be an issue, has the ability to opt in to the codified business judgment rule.
and does it also apply for like limited liability companies?
So limited liability companies already have the contractual right to establish the duties of their board. This law does not change anything for limited liability companies.
Perfect. Thank you so much.
Thank you, Senator. Senator, is there any other questions for these witnesses? Thank you each for being here. Thank you for your continued work and consultation. This is a process, of course. There'll be there more language is being considered, and a lot of stakeholders are involved. Thank you each for your expertise, and we'll be consulting you again. Thank you for being here.
Thank you so much, Chairman.
Thank you.
And thank you.
We'll open public testimony on Senate Bill 29. And the chair calls Glenn Hamer. There's Glenn. Is there anyone else wishing to testify on, for, or against Senate Bill 29? A number of individuals and groups have registered their position not wishing to testify, and that'll be in the record, of course. Glenn, Mr. Hamer, welcome back. Introduce yourself. Give us your testimony.
Mr. Chairman Hughes, members of the committee, my name is Glenn Hammer, President and CEO of the Texas Association of Business. We're the state chamber for the state of Texas. In addition to all of our direct members, we represent about 250 chambers throughout the great state of Texas. And Mr. Chairman, I just want to start by thanking you and the Lieutenant Governor for your extraordinary leadership on this bill and so many other efforts that have made Texas the best place in the country for business. We would actually say now, with our $2.6 trillion economy and growing, we have the best economy in the world. But now that SpaceX is headquartered here and incorporated here, why don't we just say we have the best economy in the galaxy? SB29, Mr. Chairman, makes the state even more competitive. I'll just say the testimony from the three previous witnesses was just absolutely inspiring. The bottom line is Delaware has blown it. I mean, when you think about what's happened with California, you're going to see that same sort of migration of businesses incorporating and reincorporating in the state of Texas. It's a huge deal to codify the business judgment rule. It's a huge deal to work on the derivative suits, and this nice laminated cover of that Governor Abbott wrote last week in the Wall Street Journal really says it all about the importance of business courts in the state of Texas. Thank you, Mr. Chairman, and members of the committee for all that you do to make Texas the best place for business.
Glenn, thanks for your testimony. As long as I've known you, I can't believe I mispronounced your last name when I called you up here. I do it about half the time, but
It's close enough.
Glenn is easy, and so is Hammer. Members, any questions for the witness? So let me ask you one more thing.
Sure.
So obviously a lot of corporations, as we've heard, are not happy in Delaware, looking for someplace else to go. So my messaging expert says we should call this bill Dexit. What do you think? You like that?
I like it. I like it. I don't have a background in marketing, but this is such a big deal, and the message is out really to the entire country and the whole world that we're the best place for business. And when you think, this is a rhetorical question, if you have an internal issue as a business, are you going to be better treated in Delaware or the state that has become the economic engine of the United States of America? I mean, Mr. Chairman, if I could just say, I mean, for the 13th straight year, we won Site Selections, Magazine's Governor's Cup, that for the most economic development projects. We doubled up the second place finisher. It's like we win the economic development Super Bowl every year in the state of Texas by a score of about 50-10. And this just accelerates our lead. 20-plus year CEO Magazine's top state for business. So thank you. And this could be a nice economic, I would predict as companies incorporate and reincorporate here, this will also add to the record $23 billion surplus that the state of Texas holds. So, Mr. Chairman, I just want to, again, commend you, the Lieutenant Governor, for all of your work to keep Texas on top and to make us even more competitive in this area of incorporations and reincorporations. And I want to thank our friends at Texans for Lawsuit Reform as well, a great leader in this state.
Well, thanks, Glenn. Members, any questions for Mr. Hammer? Thanks for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 29? Seeing and hearing none, public testimony is closed. Senate Bill 29 is left pending at this time. We have motions in writing from Senator Betancourt and Senator Paxton. Without objection, those will be granted. What's next? How many witnesses?
Chair lays out Senate Bill 1033 and recognizes its author, Senator Hughes, to explain the bill.
Thank you, Dean. Senate Bill 1033 is a matter that was addressed last session by the Senate. Interesting fact pattern that has arisen and to be dealt with. Under current law, if a primary runoff candidate withdraws after the primary, but before the runoff, the remaining candidate is declared the winner and will advance the general election. This is true even if there's a third place candidate who could participate in the runoff. SB 1033 would resolve this by amending section 172.059 of the election code. This bill ensures that if a candidate who advanced from a primary election to the runoff then withdraws before the runoff is held, the candidate with the third highest votes would replace her on the runoff ballot. And of course, this gives a time frame in which they must withdraw. And members, if this is helpful, let's say there are three candidates running in a primary, Republican or Democrat, or what other party might have a primary in Texas. And so no candidate receives 50% of the vote. Let's say the first place candidate gets in the 40s. The second and third place candidates are each in the 20s. So second and third are pretty close. First place candidate got close to that 50%. So no one broke 50%. So there's a runoff between the first place candidate who's in the 40s and the number two who's in the 20s. The first place candidate then withdraws right after the primary before the runoff. Conventional wisdom would be that 2 and 3 move up and have a runoff, but that's not the law in Texas. Number 2 is the winner. And so this bill says in such a situation, if the first place candidate withdraws after the primary but timely before the runoff, the second and third place candidates would move up and then participate in the runoff. Obviously, the goal being that the candidate wins, which has the most support possible. Senate passed this last session, didn't make it all the way through the process, and that's what the bill does. I yield for your questions.
Are there questions of the author? There are none. Do we have invited testimony? There is no invited testimony. The floor is now open for public testimony. The chair calls Ed Johnson and Fran Rhodes. Mr. Johnson, please begin. You know the drill.
Ed Johnson. I'm here representing Harris County Ballot Security and myself. Just a little comment, maybe something to think about in this. You're moving the cutoff period from the 3rd day to the 5th day in the bill. When you're actually trying to run elections, especially runoff elections, it's a very short window to get all the work done for the logic and accuracy test to produce a ballot 45 days before the election to mail overseas. Maybe consider letting the logic and accuracy test proceed, because removing a name from a ballot is a really easy thing to do. Adding one creates all kind of problems because you got all of the ballot styles done, but removing one doesn't affect it much. But you could do the test, and then maybe after you do that, do just a test on that race that you removed or you added a name to. And that would allow election departments to proceed with producing the ballots in order to get them mailed overseas in time.
Thank you. Other questions of the witness?
Madam Chair,
Senator Betancourt.
Ed, what you're saying is that you would like to have a incremental test done just on the adding back of the logic test, of adding back the new candidate,
yeah,
and not have to re-logic test the entire ballot pattern, right?
Correct. Well, even the fact you have to announce you're having your test 3 days before it happens, so that would maybe fall within this 5-day window. And
so you should cut that to a day or something?
Cut it to a day and let you know.
Be happy to do an amendment whenever, but that's I think the point of cutting the logic and accuracy test back to one ad after it's been done is a good thing.
Yes.
Thank you. Ms. Rhodes?
Fran Rhodes, True Texas Project, representing myself and True Texas Project in favor of this bill. As I've said before, I'm always in search of common sense. This bill is common sense. Urge passage. Thank you.
Thank you so much. Other questions of the witness? Thank you very much. Is there anyone else who would like to testify for, against, or on Senate Bill 1033 by Senator Hughes? If not, public testimony is closed and the bill will be left pending. Chair lays out Senate Bill 1362 and